While President Trump marks his first 100 days in office, a Michigan Democrat has filed the first articles of impeachment of the administration. Our Elaine Rojas Castillo spoke with the congressman to learn more about the move.
We do not have kings, we have president. And there is a reason why.
On Monday, 13th District Representative Shri Tanadar announced that he filed 7 articles of impeachment against President Trump.
The activities of this president are unconstitutional. The activities of this president, he has no regard for democracy.
The move marks the first time this year that a House Democrat has officially tried to impeach the president or a member of his administration. In his filing, Tanadar accuses the president of obstruction of justice, abuse of power, violation of power, bribery, and corruption, with particular focus on the mistaken deportation of Kilmar Abrego Garcia and the Department of Government Efficiency eliminating funds and government jobs without congressional approval.
Hey world, Adam is here. This happening right now, tonight. Formal impeachment articles, 112 pages with 3 specific federal charges, were filed against Trump, backed by declassified evidence and bipartisan support. Washington immediately erupted, with 50,000 people flooding the streets around the Capitol within hours. This isn't political theater. The charges are concrete, the coalition is real, and by all accounts, this moment feels fundamentally different from anything that's come before.
Because they have the power. We have but one power that we can use without the consent of the other side. That one power is impeachment. One power. The power to impeach. And we are in a countdown. We're in a countdown because whether the president likes it or not, whether I like it or not, the people of the country want to see him impeached. And whether he likes it or not, or whether I like it or not, or anybody else, he is going to be impeached before he leaves office again.
The articles are 112 pages, official stamp, filed in the congressional record forever, and the 3 counts inside them pull together every thread of this crisis into a single devastating legal document. Count 1 is Iran war perjury under the federal false statement statute. Count 2 is Epstein obstruction. Count 3 is $12.3 billion in unauthorized military strikes.
Article 1, obstruction of justice and abuse of executive power. Article 2, taking away Congress's power of the purse. Article 3, abuse of trade powers and international aggression. Article 4, violation of First Amendment rights. Article 5, creation of an unlawful office establishing the so-called Department of Government Efficiency, DOGE, and giving Elon Musk unconstitutional power over our government and personal data. Article 6, bribery and corruption. Article 7, tyrannical overreach.
And the evidence attached to these charges is not speculation. It is not anonymous sourcing. It is declassified memos. It is 60,000 plus Epstein file mentions. It is the sworn concession filed today by the president's own lawyers confirming that the cost figures presented to Congress were client-directed minimizations and that the records confirm the congressional bypass. Think about the sequence of just today alone. The president's lawyers filed their sworn concession and then quit. The gag order was already in place. The criminal arrest brief was already in the federal record. The bipartisan war powers letter with 85 signatures was already filed. The Attorney General's bipartisan collapse was already locked in. And then at 7:45, the impeachment papers dropped, sinking every single one of those prior developments into a single legal document that now sits in the congressional record forever. Within an hour of the papers becoming public, predicted conviction odds hit 90%. 90%. That is the highest number of this entire week in a market where serious legal and political analysts put actual stakes on outcomes. And the 25th Amendment odds sitting at 72% with cabinet members reportedly moving from wavering to deciding is the number that tells you the executive branch itself is now responding to the papers in real time. The vote projection is 227 to 208. That is not a projection that carries uncertainty anymore. It is a count. It is the specific tally of members who have committed to their vote. And that number, with the key Republican signatories confirmed and the 12 Bondi-related GOP defections locked in, is as close to a guaranteed outcome as anything in American legislative history gets before the gavel falls. This is wild. This is genuinely, historically wild, and I need you to understand right now that what dropped at 7:45 tonight is not a political document. It is not a partisan statement. It is a formal legal charging document signed by members of both parties, citing federal statutes, backed by declassified evidence, corroborated by a sworn defense concession, filed in the permanent congressional record that will follow this presidency for the rest of American history. Let me break down the three charges because the specific construction of the articles is deliberate, and each count does a specific job in the overall legal architecture. Count 1 is Iran war perjury, and what makes this count so devastating is what the evidence package attached to it contains. Declassified memos proving that the military strikes bypassed Congress without the legally required war powers authorization, and the president's own lawyers filed a sworn concession earlier today confirming that the cost figures presented to Congress were client-directed minimizations, and that the records confirm the congressional bypass. The articles attached those declassified memos as irrefutable evidence, and the sworn concession from defense counsel filed in federal court today is now part of the corroborating record that any senator evaluating this count will have access to. You cannot look at a perjury charge citing declassified memos as evidence backed by the defendant's own lawyer's sworn concession and find reasonable doubt. The evidence structure does not leave room for it. Count 2 is Epstein obstruction, and this count does something specific in the overall architecture of the articles. It ties the Justice Department conduct, the subpoena defiance, the redactions that Republican members have characterized as deliberate co-conspirator protection, directly to the president, not to the attorney general, to the president. The 60,000-plus Epstein file mentions are cited in the articles directly as evidence of the scope of the connection. The Justice Department redactions protecting co-conspirators are cited as evidence of the obstruction pattern, and the unredacted victim claims now part of the court record through the criminal referral are cited as evidence of what the obstruction was designed to conceal. Count 2 is the count that connects the Iran war conduct to the Epstein conduct and says this is a pattern, not an isolated incident, and the pattern demonstrates the high crime standard required for impeachment. Count 3 is the $12.3 billion in unauthorized military strikes, and this count operates most directly at the constitutional level because it is not just a criminal charge. It is a charge about the fundamental relationship between the executive and legislative branches of government, the War Powers Resolution, the congressional authorization requirement, the 48-hour notification obligation, all of them violated, all of them documented in the declassified memos, all of them cited in the 85-signature bipartisan congressional letter filed earlier today, all of them confirmed in the specific language of client-directed cost minimization, and records confirm congressional bypass in the defense team's sworn concession. Count 3 is the count that says this presidency operated outside the constitutional framework that governs the use of military force. And here is the documented evidence that it did. 3 counts, 3 independent legal theories, 3 separate documented evidentiary bases, all arriving at the same constitutional conclusion, and all of them sync explicitly. The articles cite the criminal arrest brief, the gag order, and the lawyer admissions as part of the supporting record. The impeachment articles and the federal criminal proceedings are referencing each other in their own official documents. The legislative and judicial branches are operating in documented coordination on the same evidence base. That is an extraordinary legal architecture, and it is now in the permanent congressional record. Now let me talk about what is happening in the streets because the 50,000 people outside the Capitol tonight are not just a backdrop to the political story. They are a political fact in their own right. 50,000 people on a weeknight in March flooding the streets of Washington, D.C. within hours of the impeachment papers dropping. That number and the speed with which it materialized tells you something about the pressure that has been building in this country for weeks underneath the political and legal headlines. The gas riots that have been happening on the East Coast are not separate from the impeachment story. They are the economic dimension of the same crisis. The Iran war cost that drove gas prices to levels crushing working Americans, and the people paying those prices at the pump are now in the streets outside the building where the vote is going to happen. The National Guard deployment tells you that the law enforcement assessment of the situation is serious. The Guard does not deploy for normal protest activity. They deploy when the assessment is that the situation requires military-grade crowd control capacity on standby. And deploying the Guard on the same night the impeachment papers dropped, with gas riots already active on the East Coast, with thousands of people in the streets, with the Capitol briefly evacuated earlier this week, is an operational decision based on a serious threat assessment. The clashes between protesters and police are the visual that every international news outlet is going to lead with tomorrow morning. And what those visuals communicate to every ally capital, every adversary, every diplomatic audience watching, is that the American political crisis is now also a public order crisis. That the domestic consequences of the Iran war, the economic pressure, the political breakdown, the legal collapse, have now reached the streets in numbers that require National Guard response on the night the impeachment papers dropped. Let me connect tonight's articles to the full week of developments, because the 112-page articles did not arrive from nowhere. They are the formal legal crystallization of everything that has been building. The resignation letter from the Pentagon official established the inside account, no imminent threat, Iraq playbook repeated, lobby pressure, unauthorized decision-making. That letter is cited in the articles. The judicial removal signal provided the foundation. That document is cited in the articles. The criminal referral established the prosecutorial framework. The 3 charges, the 18 exhibits, the mandatory custody demand. The articles sync with that framework explicitly. The gag order and the contempt mandate are referenced. The lawyer admissions are part of the corroborating record. The articles build on every single development this week. The press conference meltdown. The Capitol Hill confrontation, the operational divorce from allies, the Oval Office speech that backfired, the Epstein files, the Attorney General collapse, the Congressional War Powers letter, the lawyer withdrawal, all of it fed into the 112-page articles that dropped at 7:45. The articles are the formal legal document that gathers every threat of this week's crisis into a single charging document, and that document is now in the permanent congressional record with a vote scheduled, with projected passage, and with 90% conviction odds in the markets. The 25th Amendment at 72% with cabinet members reportedly moving from wavering to deciding tonight is the executive branch's real-time response to the papers dropping, because cabinet members who have been calculating odds and watching developments all week are now looking at formal impeachment articles citing the same evidence they have access to internally and making the constitutional decision against that specific and official backdrop. The papers dropping made the situation more concrete for everyone, including the people inside the building who have the authority to invoke the fastest constitutional removal mechanism available. The 90% predicted conviction odds are the market summary judgment on the week. Every development, every legal filing, every political defection, every sworn concession, every street-level protest, all of it priced into a single number, 90%. That is the legal and political community's collective assessment of where this ends after looking at everything that has happened today and everything that has built to this point. The 112-page articles dropped with 3 counts corroborated by a sworn defense concession, and that combination makes the legal case effectively unanswerable. A federal criminal charge is difficult to prove beyond reasonable doubt when the evidence is contested, when the defense has counter-arguments, when the factual record is genuinely disputed. That is the normal condition of federal criminal proceedings. But this is not that condition. Count 1 cites declassified memos and is corroborated by the president's own lawyers confirming the congressional bypass. The defense has already confirmed the prosecution's central claim under oath before the articles even dropped. Count 2 cites Epstein file mentions and Justice Department conduct that 12 Republican members of Congress have already characterized as criminal in a bipartisan formal resolution. Count 3 is documented in the same declassified memo and corroborated by the same sworn defense concession. 3 counts, each one independently corroborated, 2 of them corroborated by the defendant's own lawyers under oath, 1 corroborated by a bipartisan congressional resolution. The reasonable doubt space has been closed from the inside by the defense team's own sworn filings before the Senate has even begun deliberating, and the 4 attorneys who withdrew today are not available to argue the other side. 50,000 people in the streets with National Guard deployed means the political crisis has become a public order crisis, and that changes the calculus for every remaining decision-maker. Cabinet members evaluating the 25th Amendment are making that decision while 50,000 people are in the streets of D.C. and the National Guard is deployed. Senate Republicans calculating their conviction vote are making that calculation while gas riot footage from the East Coast is running on every screen in every office in the Capitol building. House members preparing to cast the impeachment vote tomorrow are preparing it while the police lights from the street protests are visible from their office windows. The street-level reality is not separate from the institutional decision-making. It is the backdrop against which every decision gets made. And that backdrop tonight is the most politically charged environment that Washington has operated in during this entire crisis. The 72% 25th Amendment odds combined with 90% conviction odds in a vote scheduled for tomorrow means the resolution window is now hours, not days. All week we have tracked the resolution window shrinking, and tonight, with the papers officially in the record, with the vote scheduled, with 90% conviction odds, with 72% 25th Amendment activation, with 50,000 people in the streets, with the National Guard deployed, with the marshals mobilized, and the Secret Service running extraction protocols, the resolution window is not a projection anymore. It is a schedule. The vote is tomorrow. The federal hearing is days away. The 25th Amendment activation, if it comes before or concurrent with the Senate trial. The jail prep is operational. The war room is empty. The lawyers are gone. The papers are filed. The streets are on fire. Here is the complete picture of where we are right now. Impeachment articles dropped tonight. 3 counts: Iran war perjury, Epstein obstruction, unauthorized military strikes, citing declassified memos and Epstein file mentions as irrefutable evidence, syncing explicitly with the criminal arrest brief, the gag order, and the sworn lawyer admissions. Thousands of protesters in D.C. streets, National Guard deployed, gas riots on the East Coast, predicted conviction odds at 90%, 25th Amendment at 72%, vote projection locked with Republican defections confirmed, 4 attorneys withdrawn, war room empty, D.C. marshals mobilized, Secret Service extraction protocols active, criminal referral corroborated by the president's own lawyers under oath, all of it on one day, all of it building toward a vote that happens tomorrow morning. A vote that has projected passage, a vote that carries 90% conviction odds in its wake, a vote that activates federal custody proceedings, 25th Amendment considerations, and Senate trial timelines simultaneously upon passage. The papers dropped at 7:45. The streets erupted, the National Guard deployed, the lawyers are gone, the war room is empty, the count is locked, the vote is tomorrow. This is not the beginning of the end. This is the end, and it starts in the morning.